We're in the BARBRI Commercial Outline for Criminal Law, page 69, the very bottom of which, within section 9, offenses against property. D, therein, titled robbery. Robbery, a felony in all jurisdictions, consists of the following: a taking. I don't know if I have this term in my note cards because I just thought it was synonymous with larceny, but guess what? It's not. And let me tell you why. The taking is the same. You have the taking. But then you also have of personal property of another. Now, the thing is, carrying away is not part of this definition, whereas it was part of the larceny definition. From another's person or presence is another element distinct to robbery. And person or presence, and this is how it makes it different, is by force or intimidation. You don't have that element in larceny. Intimidation with the intent, and this is the same, with the intent to permanently deprive the owner thereof . Now, what can we say more about robbery? Thus, robbery is basically an aggregated form of larceny in which the taking is accomplished by force or threats of force. 1. Force or threats necessary. If force is used, it obviously must be sufficient to overcome the victim's resistance. If threats are used, they must be threats of immediate death or serious physical injury to the victim, a member of her family, a relative, or a person in her presence at the time. A threat to do damage to property will not suffice, with the exception of a threat to destroy the victim's dwelling house. So for this reason is why we have a defense against robbery. We can use non-deadly force to protect our property from robbery. Not so sure if the same is true for larceny. Property, so this is 2. Property must be taken from person or presence of victim. The property must be taken from some location reasonably close to the victim, but it need not be taken from her person. Property is in the victim's presence if it is in her vicinity. Property in other rooms of the house in which the victim is located is in her presence. 3. Force or threats must be used to obtain property or immediately retain it. The force or threats must be used either to gain possession of the property or to retain possession immediately after such possession has been accomplished. Example: A reached into B's pocket without B's knowledge and removed B's wallet. B felt the wallet slip out, turned around, and grabbed A as he moved away. A struck B, rendering her unconscious, and ran. Is A guilty of robbery? Held yes. The force was used to prevent the victim from immediately apprehending A and regaining the property. Thus, it is sufficiently related to the taking. 4. Aggravated robbery. Often, statutes create a form of aggravated robbery, usually defined as robbery accomplished with a deadly weapon. Okay. But I think it's a felony always. Yeah, it's always the felony. So aggravated just makes it like maybe more punishment. So anyway, extortion. We're already done with robbery. We've made our point, haven't we? Extortion. What's extortion? Extortion is an offense that generally has been expanded by modern statutes far beyond its initial common law definition. The common law definition, collection of unlawful fee. The common law misdemeanor of extortion consisted of the corrupt collection of an unlawful fee by an officer under color of his office. Modern definition includes blackmail. In modern statutes, extortion or blackmail is defined as obtaining property from another by means of certain oral or written threats. The prohibited threats often include threats to physical harm or victim to others, or threats to do damage to the victim's property. Under some statutes, the crime is completed when the threats are made with the intent to obtain money or something of value. The threat is the presence of the offense. Under other statutes, the money or property must actually be obtained by means of the threats. A and B. Threats need not involve immediate or physical harm. And B, property need not be in victim's presence. So you can say, I'm going to take your car to work if you don't let me have it. Mom, mom. And or wait, what am I talking about? And B, okay, property need not be in victim's presence. Got it. Whatever. Anyway, F, receipt of stolen property. The common law misdemeanor of receipt of stolen property is substantially identical to the modern offense. The elements of a crime are Romanet 1, receiving possession and control, Romanet 2, of stolen personal property, Romanet 3, known to have been obtained in a manner constituting criminal offense, Romanet 4, by another person, and Romanet 5, with the intent to permanently deprive the owner of his interest in the property. Possession. Manual possession of the property, while insufficient for receiving, is not necessary. It is also receiving if, Romanet 1, the thief places the stolen property in a place that the defendant has designated, or Romanet 2, for profit. The defendant arranges for a sale of the property by the thief to a third person. 2. Stolen property. Most jurisdictions define stolen property broadly to include property obtained by commission of any of the property offenses that we discussed about. However, the property must have stolen status at the time it is received by the defendant. Thus, if stolen goods have been recovered by the police and are used in an undercover operation with the owner's permission, the goods are not stolen, and the defendant cannot be guilty of receipt of stolen property. Mistake fact theory. However, the defendant may be guilty of attempt to receive stolen goods. So the attempt is still there, even though it's a legal impossibility. Yeah, legal impossibility. What is the difference between legal impossibility and mistake of fact? Because we're mistaken on... A mistake of fact would be not knowing that the property's stolen. So, whatever. G, statutory changes in property acquisition offenses. Modern criminal codes and the MPC have substantially altered the common law. Among the major changes are the following. 1. Consolidation of offenses into theft. There is a growing tendency to consolidate larceny, embezzlement, false pretenses, and receipt of stolen goods under a single heading, theft. This has happened in California. It is important to note that theft is a modern statutory crime, not a traditional common law offense. Why is this being done, right? I can speak to that if it's not being spoken to already. Expansion of property subject to larceny. The things subject to the offenses have often been expanded to cover services, documents, and intangibles, as well as joint property. 3. Rejection of asportation for larceny. Some jurisdictions have rejected the requirement of asportation and require only that control of the property be obtained, meaning that you haven't left the store yet. Rejection of technicalities of trespass requirement. A number of jurisdictions have replaced the detailed technicalities of the trespass requirement by a simplified requirement that the defendant have obtained unauthorized control over the property. I'm really hoping that the definition of trespass is somewhere in the offenses against dwelling section, because I do not know what the definition of that is. The best I know of it is from tort law, which I took for 3.5 weeks. The reason why these offenses against property are being consolidated into theft is because if you charge a defendant with larceny, but you should have charged the the defendant with extortion, and the crime doesn't meet the elements of larceny, however, it would have met the elements of extortion, that defendant is not guilty of larceny, and that defendant is acquitted of the offense, and I don't believe that that defendant can be tried again for the same criminal activity, so that defendant goes without punishment. So when you stick them all in the theft department, then you only have to prove the elements of theft, which is easier to do for lawyers according to the theft elements of theft, or the way in which the jurisdiction has written that legislation. Okay, so forgery. H. At common law, forgery and uttering a forged instrument are separate offenses. Forgery consists of the following: making or altering of a false writing with intent to defraud. Uttering consists of offering as genuine an instrument that may be the subject of forgery and is false with the intent to defraud. 3. Writings that are possible subjects of forgery. Any writings that has apparent legal significance is a potential subject of forgery. Writing includes typewritten, printed, engraved, and similar material. Example: A drafts and signs what purports to be a letter of introduction from a local physician and a letter of recommendation from a firm presented as a former employer. Both are false. Has A committed 1, 2, or no forgeries? Held: 1 forgery. The recommendation has apparent legal significance because one who recommends another may incur legal liability if his recommendation is false. Thus, it can be the subject of forgery, but the letter of introduction has only social significance and cannot be subject of forgery. Writings that derive their value from the mere fact of their existence, historical or artistic value, cannot be subject to forgery. Example: A painted picture and signed it. A painted a picture and signed it Rembrandt. She then sold it to X, representing it as an original Rembrandt. Is A guilty of forgery? No, because a picture and signature derive the value from the fact of their existence. Note: A did commit false pretenses by the sale. 4. Required falsity. Writing itself must be a lie. It is not sufficient that the writing contain a false statement. The writing must represent itself to be something that it is not. Example: A, in charge of a warehouse, issues a warehouse receipt that represents that the warehouse has received certain grain. It has not. Is this forgery? Held: no. The warehouse receipt contains a misrepresentation, but it is what it purports to be. Example, a warehouse receipt issued by one with authority to issue it. B obtains blank receipts from A's warehouse, fills them in so they represent that certain grain has been received, and signs A's name. Is this a forgery? Hell, yes. The instrument purport to be what they are not, i.e. warehouse receipts issued by one with authority to do so. 5. Required making. A. Entire instrument or material altercation, or B. Fraudulently obtaining signature of another. Entire instrument or material alteration. Forgery can be committed by the making of an entire instrument. It can also, however, be committed by altering an existing instrument if the alteration is material, that is, if it affects a legal right. Alteration may be in the form of changing some of the writing, adding to the existing writing, removing some of the existing writing, or improperly filling in blanks left by the signer. B. Fraudulently obtaining signature of another. If the defendant fraudulently causes a third person to sign a document that the third person does not realize he is signing, forgery has been committed. But if the third party realizes he is signing the document, forgery has not been committed, even if the third person was induced by fraud to sign it. 6. Required intent to defraud. The defendant must have had the intent to defraud, although no one need actually have been defrauded. It is not necessary that she intended to do pecuniary harm. It is sufficient if she intended to harm another in any way. Now, malicious mischief is letter I in the Defenses Against Property section. So in common law, misdemeanor of malicious mischief consists of malicious destruction of or damage to property of another. Never heard of it. Cool. Damage required. Destruction of property is not required for malicious mischief. All that is necessary is that some physical damage be done that impairs the utility of the property or materially diminishes its value. And last, state of mind required malice. Malice requires no ill will or hatred. It does, however, require that the damage or destruction have been intended or contemplated by the defendant. And that is the end of Section 9, Defenses Against